Yes.
Item number 1.
Made, please, Your Lordship.
The what is set the watch. Watch me देगी अच्छी कोई का. Yes.
Yes, my lord. Lord, we are here before Your Lordship challenging the order of learned single judge. Learned single judge, relying on the judgment of this honorable court by division bench, held that the Sirdar of Mawlong area has a right to collect customary tolls from the vehicles laden with minerals. Our case is, my lord, that the entire mines and minerals and transportation of minerals are covered by MMDR Act, and therefore the Sirdar has no customary right, my lord. My short case is this only, my lord. For that, Your Lordship will see page 71, which was the order which has been challenged before Your Lordship. Page 71, A of the paper book.
Yes.
Now, if Your Lordship kindly see page 71A, which is a typed copy, my lord. With reference to the subject cited above, I am including here with a copy of the order,
Yes.
a detailment of magistrate for dismantling of toll gates in East Khasi Hill district. In this connection, I am to request you to kindly depute magistrate in place of so and so, run by East Khasi, run by Sri Rest Mawa, authorized by Mawlong Sirdarship to collect 200 per truck of coal, limestone, boulder as it is under your jurisdiction. A copy of the High Court order dated 3rd May 2016 is enclosed here with, for ready reference, my lord. So dismantling of toll gate was carried out, my lord, by Deputy Commissioner East Khasi Hill District, my lord. This order was, my lord, challenged by the writ petitioner before Your Lordship. And the prayer, if Your Lordship will kindly see page 104 of the paper book, my lord.
Sorry. Page.
Page, Your Lordship will find, it starts from page 72, my lord, the writ petition.
Just a minute. Just a minute.
Oh no, this is the other one. So I'm sorry, my lord. This is the writ petition will Your Lordship will find. It is part of the compilation, my lord, which Your Lordship will find compilation number 3. There are 3 compilations, my lord. Compilation number 1, compilation number 2, compilation number 3, my lord. Compilation 3, my lord. Yes, my lord. Volume number 3. Volume 3, Your Lordship will find at page 44, my lord, is the prayer of the petitioner.
So basically, Mr. Counsel,
Yes.
basically, Mr. Advocate General,
Yes,
is that whether this particular person who
Yes.
claims himself to be the agent
Yes, my lord.
of that Khashi Council,
Yes,
the district council,
Yes, my lord.
is entitled to collect the toll plaza
Yes.
by exercising his customary right.
Yes, my lord.
So if it is a customary right, then he has.
Yes.
If it is not a customary right, he doesn't have.
Yes, that's a short issue.
Now, subject to correction, this district council or regional council,
Yes, my lord.
not this two, other two books are there. District council or regional council, they are all coming under the sixth schedule.
Yes, my lord.
So the powers of the district council or the regional council are also set in the statute in the constitution itself.
Yes, my lord.
In the sixth schedule.
Yes, my lord.
So if those authorize, say, district council or the regional council, as the case may be,
Yes, my lord.
because in this case it should be the district council, because
Yes,
this
madam.
person
Yes,
is
madam.
part of the district council where he is
Yes.
residing,
Yes, my lord.
or the toll plaza is situated.
Yes, my lord.
So if the district council doesn't have the power,
Yes,
then
madam.
whether this particular person would have the power to collect the toll plaza.
Yes, my lord. His right cannot be independent of district council, my lord. His right has to flow from the right of the district council. If district council does not possess the right under the constitution, the customary heads are also the officials of district council. They cannot collect the toll, my lord. So for that, my lord, I will take your lordship to straight away to the powers of district council in 6th schedule, my lord. Procedure.
Okay. Council. Two.
Yes, lordship. Kindly see the 6th schedule, my lord. And before I take your lordship to 6th schedule, Article 244, your lordship may kindly see.
Now, suppose Mr. Advocate General will take it that this power is not vested with the district council or the regional council.
Yes, my lord.
But still, is there any power, if it is established to be customary,
Yes, my lord.
which gives him the right
Yes,
to
ma'am.
collect the toll plaza? Is there any other provisions in the constitution?
No, there is no such provision, my lord. I will take your lordship to the all provisions. Kindly see first Article 244, my lord, under which 6th schedule is provided, my lord. 244(2), which applies to us, my lord. 244.
Yes.
The schedule and tribal areas, lordship
Yes.
has Article 244(2), my lord.
So you mean to say that if there has been any customary power prevailing prior to the constitution or prior to this sixth schedule was inserted
Yes, my lord.
in the constitution,
Yes, my lord.
all these stands abrogated or denuded
Yes, my
by
lord.
reason of these.
Yes, my lord. There is a constitution bench judgment directly on this point. I will place it, my lord, after I on this issue only, you know. And it's way back in 1961, SC 276, the Honorable Supreme Court has held that all powers have now, after the coming of the Constitution, does not survive. Only 6th schedule and the constitutional provision will survive, my lord. But first, your lordship, kindly see Article 244. Article 244, Part 1 covers 5th schedule, my lord. We are concerned with 6th schedule, 244.2. The provisions of the 6th schedule shall apply to the administration of tribal areas in the state of Assam, Meghalaya, Tripura, and Mizoram. So now, your lordship, kindly see 6th schedule.
Yes.
Yes. 6th schedule. Now, in 6th schedule, my lord, article paragraph 1 deals with the constitution of the various district council, my lord.
Yes.
Now, first, my lord, will see the subject to the provisions of this paragraph. The tribal areas in each part are
You are referring to?
a 6th schedule, my lord.
Yes.
And I am referring to paragraph 1.
Unless the context otherwise requires.
No, my lord, 6th schedule.
Sorry. Yes.
Yes, lordship, will see paragraph 1. Autonomous districts and autonomous regions. Subject to provisions of this paragraph, the tribal areas in each part 1, part 1, 2 and 2A and part 3 of the table appended in paragraph 20 of this schedule shall be autonomous districts. So autonomous districts have been defined, my lord. My lord, we are concerned with this part only. Then your lordship will kindly see paragraph 2.
Yes.
Paragraph 2, your lordship will kindly see paragraph 2. There shall be district council for each autonomous district consisting of not more than 30 members, of whom not more than 4 members shall be nominated by governor and rest shall be elected on the basis of adult suffrage.
So yes, these are all.
Yes, provision, my lord. Powers of district council, if your lordship will see at paragraph 3, my lord.
Paragraph 3.
Yes.
Powers of district council.
Powers of district council and regional council. The regional council for autonomous region in respect of all areas within such region and district council for autonomous district in respect of all areas within the district except those which are under the authority of regional council, if any, within the district shall have power to make laws with respect to, my lord, and the power, if your lordship will see, first is allotment to use, allotment, occupation, use or setting apart of land other than any land which is reserved forest for the purpose of agriculture or grazing or residential or other non-agricultural purposes for any other purpose likely to be promote the interests of inhabitant of any village or town, provided nothing such law shall prevent the compulsory acquisition of land, whether occupied or unoccupied, for public purpose by the government or state concerned in accordance with law for time being, so and so, my lord. Now, B, management of any forest not being reserved forest. C, use of any canal or water course for purpose of agriculture. D, regulation of practice of jhum or other forms of safety and cultivation. E, establishment of village or town committee or council and their powers. If any other matter relating to village and town administration, including village or town police or public health and sanitation. G, appointment or succession of chief or headman. H, inheritance of property. I, marriage and divorce. J, social custom. So these are the
Yes.
yes, my lord. And kindly see, my lord, paragraph 8, where power to collect land revenue is vested with the district council.
Yes.
paragraph 8 my lord, power to assess and collect land revenue and to impose taxes.
Yes.
The regional council for an autonomous region in respect of all lands within such region and district council for an autonomous region district in respect of all lands within the district except those which are in the areas under the authority of the region, if any, within the district shall have power to assess and collect revenue in respect of such land in accordance with principle for time being followed by the government of the state in assessing the lands for the purpose of land revenue in the state generally. So 8.1 is only confined to collect the land revenue, my lord. Now,
Yes.
the 8.2, my lord, regional council areas within the region and district council of district in respect of region which are under the authority of regional council shall have power to levy and collect taxes on lands, building and toll on persons and resident within the area. Tolls on persons resident within such area, my lord. So 8.2 also, my lord, confers power on district council to collect tolls on persons resident within such areas, my lord. And 3, my lord, the district council for autonomous districts shall have power to levy and collect all or any of the following taxes within such a district, that is to say, taxes on profession, trades, calling and employment, taxes on animal, vehicles and boats, taxes on entry of goods into the market for sale therein, my lord, kindly mark this, and toll on passengers goods carried and ferried. Taxes on maintenance of school, dispensary, road, tax on entertainment. So these are the taxing powers or entries.
But tolls on passengers and goods,
Yes.
district council has the power.
Yes, my lord. This is also subject to, my lord, power of the state government under paragraph 12A of this schedule, my lord. All laws made by state government will prevail over the laws made by district council. That provision is also there.
If it is in conflict.
If it is a conflict. If it is a conflict.
So, doctrine of repugnancy to that extent would apply.
Yes.
Just like when we say about union and.
Yes, same principle will apply. Here, I would say, my lord, if your lordship will see paragraph 12A of the.
No, but for the timing, there is no such act
Yes, my lord.
which overrides or is in conflict with the power of the district council to collect tolls on the passengers
Yes.
and goods.
Yes, my lord. So far as that aspect is concerned, because here, my lord, we only power which they are exercising is collecting toll from the vehicles laden with mineral, my lord, passing through their ilaka.
No, is any this if you read this phrase broadly,
Yes.
then on goods.
Now, if your lordship will see 8.3, see taxes on entry of goods into market and tolls on passenger and goods carried and in ferries. So only it is first market for sale therein and tolls and passengers and goods carried in ferries, my lord, not on vehicles and etc. And 12A, if your lordship will kindly see paragraph 12A.
Yes.
Which is specifically related to Meghalaya, my lord. Application of acts of parliament and legislature of state of Meghalaya to autonomous districts and autonomous region in the state of Meghalaya. Notwithstanding anything contained, anything in this constitution, if any provision of a law made by district or regional council in the state of Meghalaya with respect to any matter specified in paragraph 1 or paragraph 3 of schedule, or if provisions of any regulation made by district council regional in the state under paragraph 8 or paragraph 10 of the schedule is repugnant to any provisions of law made by legislative state with respect to that matter, then law or regulation made by district council, as the case may be, or regional council, whether made before or after law made by legislature of state, shall to the extent of repugnancy be void, and law made by the legislature of state shall prevail. So it clearly confers or provides for giving law of the district council way to the laws made by state government, my lord. And lordship is aware that under Mines and Mineral Regulation Development Act, power has been conferred by the parliamentary enactment to the state government to enact the rules and regulations for movement, collection of toll, transportation challan. So entire field is occupied and law is already there, my lord. This cannot be interfered or tinkered with by district council in the name of customary toll. And customary toll, your lordship has observed that customary toll has to be shown that this has been in practice, this has been continuing, my lord. All those materials are required to be placed before the Honorable Court to prove this point, my lord. Coming back to the point, my lord, your lordship has observed regarding power of the district council. If your lordship will see compilation 2, where the Honorable Supreme Court has dealt with this aspect at page 186 of the compilation 2.
Page
186 of compilation 2, my lord. This is the Constitution Bench judgment, my lord.
Yes.
And this is T. Kaji versus U. Jora Manu. And page 190, if your lordship, paragraph 8.
Yes.
Paragraph 8, your lordship has seen. Paragraph, your lordship kindly see paragraph 10. And at page 192 of the top, my lord, first line. Though different now, after fourth line, my lord, now para 2 of district council would not extend to subject enumerated in para 3.1. Now para 2.4 provides that administration of autonomous district council shall vest in the district council, and in this And this, in our opinion, is comprehensive enough to include all such executive powers. It is true that where the executive powers impinges upon right of citizen, it will have to be backed by appropriate law. Where executive power is concerned only with personal admission, it is not necessary. My lord, in that was the context, my lord. Here also, it is the right of the citizen to carry on trade, my lord, is getting affected, my lord. And precisely on this issue, my lord, next judgment, if your lordship will see page 180, page 196, my lord. District Council of Juwai, Autonomous District Council versus others, my lord. And
No, this judgment you are citing for,
but for the purpose of showing that all their powers after coming of the constitution, my lord, will flow from 6th schedule only. And they do not have independent power to collect any tax, toll, customary dues. All those powers of the relics of are relics of the past. After coming of the constitution, they do not have independent power. I will cite only 2 judgments of Supreme Court and 2 judgments of this Honorable Court where this power has been held to be bad in law. If your lordship will see the next judgment, 1 paragraph only of the Constitution of the Supreme Court only, my lord, 1986, 4 SCC, page 38, page 196, my lord. Page 196, my lord, and page 198, if your lordship kindly have it, page 198. This is the order passed by the district council, my lord, for, and the notification is there in the middle of the page at 198. Middle of the page, in exercise of power conferred under section 8 of so and so, Executive Committee of Juwai is pleased to fix a flat rate of royalty for both red pine and white pine per cubic for all squared log pine timber irrespective of girth and classes other than pine. So this was, by this the royalty was fixed, my lord. And the Honorable Supreme Court in paragraph 7 refers to Article 244 after analyzing all the provisions of the various paragraphs, my lord, at page 1207, paragraph 16, my lord. And at the bottom, my lord, it is true since the sort is to be recovered in the act is not royalty, since the forest does not belong to district council. Amount claimed
yes.
And page 207 at the 206 bottom, my lord, last 2 lines, the amount claimed by way of royalty under the notification is compulsory exaction of money by a public authority for public purpose enforced by law and is not a payment for services rendered. It is truly in the nature of tax. In the High Court, various claims were put forward to support the impugned levy. It was contended that royalty in question comes under A and C of paragraph 8.3, my lord, of the 6th schedule to the Constitution, namely taxes on profession, trades, calling and employment, or taxes on the entry of goods into market for sale of therein. It being neither of these 2 kind of taxes referred to above, High Court rightly rejected the above contention. So the two judgments of the Honorable Supreme Court, and my lord, your lordship has seen the impugned order, which was based on the order passed by this Honorable Court, my lord. And kindly see volume 1, because the genesis of the order passed by Deputy Commissioner was based on the order of this Honorable Court, my lord, judgment of this Honorable Court, which is part of volume 1, my lord.
You are referring to which judgment?
I am referring to Sadangu L. Dakar, volume 1, my lord, page 1. Judgment of this Honorable Court, my lord, learned single judge judgment, Justice Dinesh Maheshwari, as he then was, my lord. And in this case also, my lord, agent was running the verification check gate. Facts you lordship will find at paragraph 5. And relevant paragraph, my lord, is 15, 16, 21, 21.
But in this case, it is not a power exercised by the regional council or the district council.
Yes, my lord.
It's a person who may be a resident of a particular district council.
Yes, my lord.
He constructed maybe a toll plaza.
Yes, my lord.
It is not a construction of the district council.
Yes, my lord.
And he exercises right of collection of the fees or
Toll.
this what they call it toll plaza,
Toll plaza.
toll, exercising his customary right.
Yes, my lord.
So the power of the district council or the regional council
Yes, my lord.
may not be relevant for that because all the decisions are.
My lord, the Sirdar of the Ilaka is also official of KH, district council only.
Sorry?
The Sirdar, the person who is collecting the toll, he is also official of district council. He is appointed by district council only.
No, he may be appointed by the
Yes,
district
my lord.
council, but he is exercising his right not under the district council.
Yes, my lord. He
He's
says that
exercising-
I am
he's exercising
exercising
his right
independent.
individually.
Yes, my lord.
So the important aspect is whether the district council or the regional council have the power or not may not be a material germane to the issue. The issue is this, that suppose he is not a member of the regional or the
Yes,
say
ma'am.
district council,
Yes, my lord.
but he says that if I'm a tribe or whatever right I have,
Yes, my lord.
so I am as a customary right,
Yes, my lord.
I'm entitled to construct and collect.
Yes, my lord.
So these may not have any much relevance, subject to correction,
Yes, my lord.
on the power of the district council or the regional council.
Yes, my lord.
All these decisions are on.
The submission, my lord, is that your right to collect customary dues and as an independent right,
If it is preserved by any law,
and if it is preserved by any law, then you can exercise. Rights are already, your right to collect toll is already, or collect or impose taxes cannot flow from customary law. It has to come from the constitutional provision. In my entire endeavor was, my lord, to show that if the district council, which has been conferred with the power to run the administration in district council area, has no power to collect toll, all its functionary, because Sirdar is also one of the functionary appointed by district council, has no independent right. Under Article 265, your lordship,
here
slide.
no, there is a distinction. I may be part of a council,
Yes,
but
my lord.
I may have my individual right.
Yes, my lord.
So it's not that suppose the council to which I am a member
Yes, my lord.
may not have any right.
Yes, my lord.
Suppose they may not have any fundamental
I
right.
bow down.
Suppose they may not have any fundamental right.
Yes, my lord.
So if as an individual, my right is being infringed,
Yes, my lord.
then irrespective of the fact whether I belong to a council or not, I am exercising my right on the basis of whatever my right has.
Yes, my lord.
So in the writ petition, please show us what he says about his right.
His right is saying that I have a customary right to collect
Where
the
is
toll.
that averment?
Yes, your lordship will see that in the volume 3, my lord, at page 1, page 12, the writ starts, my lord. Page 12, your lordship, and the relevant material part. Where is yours? Where your writ starts?
Subordinate to the council staff because
Volume 2. Yes. 150. Volume 2, your lordship will have that. Volume 2, my lord, where it is there. Page 144.
There's a disclosed principle who has to challenge this. What right he has to challenge this? But if they able to come in, he cannot have an independent right. Say agent. So if anyone has agreed with the order, you should counsel. What right he has.
Paragraph 2 at page 145, my lord. First,
Paragraph 30 the village.
the writ petition number 2 is the duly elected Sardar, chief.
Paragraph?
Paragraph 2 at page 145, my lord. In fact, paragraph 1 also, your lordship may have it. The writ petitioner is a rudimentary institution of Hema Mawlang Sirdarship, consisting of 7 villages and recognized as independent Khasi state prior to enforcement of Constitution of India, having administrative, legislative as well as judicial function. Page 144, paragraph 1. The writ petition number 1 is a rudimentary institution of Hema Mawlang Sirdarship, consisting of 7 villages and recognized as independent Khasi state. Paragraph, volume 2, your lordship has volume 2, volume. Compilation 2, my lord.
No, I'm looking to the writ petition.
Your lordship will find, because there are 2 writ petition. Earlier writ petition was also on record. Page writ petition in the present case starts from page 140 of volume 2, my lord.
No, is it not? Oh, this is a different writ petition. Okay.
This.
The one village. Where is the other
compilation 2? Your lordship will find it in compilation 2.
Compilation 2.
At the top, it is written compilation 2.
Sorry. Yes, compilation 2.
And writ starts at page 140.
Compilation to page 140. This is a present writ, correct?
Yes, present writ.
The earlier writ that you referred to
It was KHDC agent's writ.
It is the verification.
Yes.
Collection of verification.
Yes, my lord.
So what happened to that writ?
That was, the writ was dismissed. Division bench also upheld the order of learned single judge. SLP was dismissed as withdrawn and review was also dismissed. So the order, to the extent of the KHDC to collect verification of toll, was held to be bad by this honorable court and attained finality.
So is there any issue there which also is...
Yes, there are 2 issues your lordship has seen. First,
in the first issue, in the first
yes,
petition, whether any of those findings should operate as a res judicata in this proceeding.
So far as power to collect, because there also finding has been recorded on Article 19(1)(g).
In the other writ petition.
Other writ petition. So that saying that if you want to collect toll, you have to back it by law.
That judgment is you have annexed.
Yes, that it's second part of the judgment of KHDC. This aspect has also been dealt. If I can just place those paragraphs, my lord.
Which compilation that is?
It is part of compilation volume 1, my lord. And straight away I take your lordship to paragraph 16, my lord.
Oh, this is the judgment. Very well.
Yes, my lord.
Just placed.
Yes, on the right also, my lord, paragraph 24, if your lordship will kindly see, paragraph,
Yes, a lot of kind of
paragraph
Yes, yes.
24,
yes, yes,
page
follow.
8, my lord, page
Yes,
8.
we followed. Yes, yes.
Neither authorized by law nor in conformity with the rights of citizens guaranteed by the Constitution, my lord. And again, division bench also elaborately deals with that aspect, my lord. So therefore, to that extent, judgment helps me, my lord, on their on the question of their right under the customary laws, my lord. Now, coming back to the writ petition, my lord, at page 140 of volume 2, paragraph 1 at page 144, my lord.
Fully correct. Fully correct. যেটুকু ছিল before constitution, এখন কিছু পাওয়ারটা চলে এসছে is possible part of the Supreme Court. Supreme Court যখন বলা বলবো যে না Supreme Court হবে তখন power দেওয়া আছে special court has been created for the district office. Cannot go by that. To that extent, what do I do? Court would have to consider. Similarly, paragraph 4 is not fully correct.
And if your lordship will see his right also, paragraph 5 at page 146, that is often a post of Sirdar chief is an elected post through franchise exercised by bona fide electorate candidate not less than 18 years old, as prepared by Khasi Hill Autonomous District Council under the said Act of 1960. So he is no longer customary head. He is elected under the Act of Khasi Hill, if your lordship will see paragraph 2 where the Act is described, my lord, at page 145. Duly elected Sirdar chief of this Hima Maulang Sirdarship under the provisions of United Khasi Hill, Jaintia Hill Autonomous District Administration of Election of Sirdar Maulang Act 1960. He is neither customary head nor after coming of the constitution he exercises any customary powers. And I have already shown the Constitution Bench of Judgment of Honorable Supreme Court, my lord, in T. Kaji, that all those powers are relics of the past. After coming of the Constitution, only provision which governs the administration of tribal areas or the provisions are 6 scheduled, my lord. The fulcrum of his case, my lord, is based on the judgment of division bench, my lord. If your lordship, that judgment of earlier judgment of us while Guwahati High Court, my lord, and that your lordship will find paragraph 9.
No, it refers to a Guwahati High Court single bench judgment.
That is a division bench judgment, my lord, of that judgment I would also place before your lordship to distinguish it. That judgment is not applicable, my lord.
No, here at page 163 is a judgment by the Guwahati High Court.
This is the judgment, my lord, of first judgment which the KHDC, Khasi Hill Autonomous District Council verification of all judgment, my lord. This is page 169, it starts.
you are referring to? Which
I'm
judgment?
referring to paragraph 9 at page 148, the judgment, and then I'll take your lordship because
158.
yes, 148 at paragraph 9.
Meghalaya Council, Commercial Truck.
Yes, my lord. And kindly see this judgment, my lord, which is part of volume 1, my lord, as page 121-156, my lord.
You are referring to paragraph?
Paragraph I'm referring to, my lord, for facts, if your lordship will see paragraph 8 or first paragraph itself, my lord, page 124. And in paragraph 3, my lord, if your lordship will see at the foot of the page at page 125, Nongstein CMC check gate at Nongstein, receipt of 300, 100, 300. These are the check gates where the toll was being collected. And after extensively examining all the provisions, my lord, T. Kaji has been taken note in paragraph 28 at page 136, my lord. And page the relevant paragraph, my lord, which on which I place reliance is page 147, paragraph 59. Is 147, paragraph 59, your lordship may have it. 57 and 59, my lord. conclusion, if Lordship will find at page 147, paragraph 57, my Lord.
Here they refer to an act of 2003. What is that act?
This act, Your Lordship will find.
Yes. Hashi Hills Autonomous District Nomination Election of
Yes, my Lord.
CM's Deputy CM election.
By which they are appointed, my Lord.
So this act is
Still in force. These acts are still in force. Because that is how the various.
So this is the district council.
This is the district council.
So Kashi Hills Autonomous is a district council.
Yes, my Lord.
In which they are nominated or appointed.
Yes, my Lord.
But you see paragraph 16 of the judgment in Meghalaya Commercial Trial.
Yes, my Lord. The state of Meghalaya in its affidavit has limited the power of council under 6th schedule of the Constitution of India to enact laws for collection of tolls by CMC within the jurisdiction of provision of Act 2003 and recited the stages though which a bill made by council is processed culminating in an enforceable instrument of law on receiving the assent thereto of the government. Deponent has indicated that responsibility in implementing act on the district council and the state government has no role in the matter. Yes, there was an affidavit filed by state government, but
So this is your stand.
This was the stand because Your Lordship, the stand was in the affidavit saying that the act has, if Your Lordship will see, I'll place the act also. Act is only in respect of appointment of CMs because under the district, it is nothing to do with power to.
No, so this affidavit has gone beyond the.
Yes, my Lord, the provisions of the act. I will place that also, my Lord, but that is not the basis on which the learned single judge has. Learned division bench has upheld the power of customary tax. That basis Your Lordship will find at page 57. Because give me this act. Give me this act also. 2003 act. Our stand is also recorded in para 20 at page 132.
Yes.
Yes, my lord.
Now, but this division bench judgment
Yes, my lord.
has recognized it to be a customary right.
Yes, my lord. And the
So
basis.
any SLP against this judgment?
Yes, it was SLP was preferred, but it was dismissed for non-prosecution. A leave was granted, appeal was admitted, but it was that order is also there.
But this judgment then staring at your face.
Yes, my lord. Kindly see how I come out of the judgment, paragraph 59 of this judgment, your lordship will kindly see.
Yes.
And first 3 lines, my lord. No post-constitutional law enacted either by Parliament or by state legislature has been cited repealing, annulling or superseding such customary practice so as to render it non-est thereby. So the judgment is based on the premise that there is no post-constitutional law, my lord. And I take your lordship to the laws which are regulating the minerals, movement of minerals, power of the state to collect royalty, tax, etc. my lord. In fact, I have culled out all relevant provisions in my written notes, my lord. If your lordship will have written notes. In my written notes, written submission on behalf of the respondent, my lord.
So the situation in the truck owner's case, operators, it's not restricted to only mines and minerals. It's restricted to all kinds of goods.
All kind of laws.
So this judgment covers all kinds of goods.
Yes, my lord. All kind of, including mineral. I will say including minerals also, my lord. That to that
So
extent.
that's why this judgment is
Yes.
staring at your face.
Yes, my lord. So, but this judgment, the premise of the judgment or basis of the judgment is that there is no law. No law was so at best it will be per incurium because all statutory provisions have not they have not been taken into consideration. My lord. If the basis of this judgment is, my lord, that there is no law which regulates the movement of because here the issue is only confined to collection of customary tolls on minerals, my lord.
No, you want to say this judgment is judgment per inquirium.
Yes, my lord, because this judgment is based on the premise that there is no law which regulates the movement of one aspect of the toll is minerals. Because toll, if your lordship has seen toll, all kind of tolls were being collected by local CMs, which necessarily included minerals also.
This I'm saying.
Yes. So, but the division bench, with greatest respect, says that no post constitutional law enacted either it is sub silentio or per incurium law. Because laws are in place, and even Honorable Supreme Court has in 2019 in the context of Meghalaya held that the state has no role, even other authorities have no role, only MMDR Act and its provisions are applicable and everything has to be so entire subject is controlled by the MMDR Act.
So which law according to you, paragraph 59, no post constitutional law, which law according to you is?
Mines and minerals.
Mines and minerals,
yes, my lord.
1959 go there.
Your lordship will have that act is also there on the record, my lord. It is part of compilation too, my lord.
What's pursuing such customary limits? Check up the name. Unless show that this statute operates in a field by which were necessary implication is analytic. Yes, we know it is by necessary implication. It's otherwise rights are preserved under 30. Approach. It's absurd, right? It's three. এটা হচ্ছে যার কাছে মিলটা আছে তার ownership is there. They are not collecting their clothes. It's sorted by someone else. But easier, let's see under the stability. Huh? The if Satan is the owner of the land, which contains minerals, and he has given this to someone else, is different. Finds in concept, not knowledge. the sentence app. So optimized verse becomes the state of the center. This is central structure. No individual value is there. So that so that way. It's what go along with what compensation.
Yes, Mr.
Yes.
So I say under Mines and Mineral Development and Regulation Act 1957, and there is another parliamentary legislation, my lord, Indian Toll Act 1851.
What you have mentioned is, Mr. Advocate,
Sorry.
in your notes.
Yes, my lord, it is in my notes. If your lordship will kindly see my notes.
Notes of
Notes of written speech. Yes, got it. Written submission on behalf of the respondents. Sorry, on the appellants. On behalf, it's a typo error, my lord. Written submission on behalf of the respondents, but it is simply on behalf of the appellant, my lord.
Yes, appellant is there. Is appellant.
Yes, your lordship will see. It is page 6, my lord, where serial number 3, because your lordship have one respondent, one appellant, my lord.
6.
Yes,
Page 6.
page 6, my lord.
Yes, yes.
Mines and mineral, your lordship has mines and mineral. You have copies.
Have a look at it. It's the same thing.
This was.
Is it the same thing? And you have also given a further note.
Yes, my lord, there was some notes. This is my. Let me another copy. There is another copy also.
I don't have it.
Define.
Page 6 of this note, my lord. My note.
Page 6. Yes.
Sorry.
Yes. This is another note. This is another note you have
Yes,
given.
yes, my lord.
This is
That
another
is the,
2 page.
yes, no 6. Give me all books.
This is another note.
We'll remove the unnecessary notes, my lord.
Appellant has given 2 notes.
Yes. And mine is written.
Have you given a
I
note?
have given one note.
Your note we do not find here.
We'll have
The
to.
first note lordship has handled, that is my note.
One more note. Take one extra copy here. So many notes, man. On this one.
But I've submitted earlier also, this is the same note. It is there in the report.
Please find out. It's in the record. Which one? We do not find it in the record.
My lord, I have already submitted. I've just seen from the court master.
Can you please spare a copy for us?
Yes, we'll
Resubmit it.
we'll check the file, my lord, and we'll place correct. If your
No,
lordship
we
will,
want to know which note we should look into.
yes, my lord, your lordships will
This
see
note
the
this is the final.
written submissions on behalf of the respondent.
What is this? Oh, this is the Respondent.
Yes, my lord, respondent.
Respondent, petitioner, writ petitioner.
Very well. No, but where is the other two-page note? This two-page note should also be looked into or not?
No, your lordship, leave that note for time being, my lord.
No,
That was submitted by Learned AG.
the Kumar Gupta is already there. No, I think yeah, short notes. These short notes, you have also given a short note.
Probably on earlier occasion, my lord, because it came for so many times for hearing, my lord. Part had so many times.
No.
We'll have to check the.
No, is it the final note?
I have to see that.
Please tell us which one is the final note. Otherwise, we'll go by the statutory and customary problem for us.
It's creating a lot of confusion.
Then have to final point to just find out.
This is your note.
We don't have this
This
one.
one. Note on submission on behalf of the applicant. This is the final note. This you have to discard. These are the two final.
It's not the purpose of
This is the notes.
Note of submission on behalf of the appellant, my lord. Kindly see page 8, my lord.
This is the only thing. Huh? Others you have returned.
Yes.
Fine.
Page 8, my lord. Paragraph 13.
No, Mr. Advocate General, is it their contention that the mines and minerals which is there, it is within their land? So suppose they are the owner of the mines or minerals, maybe, or maybe that Siddhar, who is collecting, who has constructed the toll plaza, is that you are extracting minerals from my land. Now, for the extraction of the minerals from my land, are you paying them any compensation for that, or this is the only as a I would say as a kind of a compensation or kind of giving them some
So far
benefits?
so far as if the mineral is extracted from the Ilaka, my lord, in Meghalaya, unique land tenure system is there. So the state is not the owner of the mineral. So state has no sovereign right over the mineral.
Yes, correct.
Okay, sovereign right. So they get the fees for or a license from the person who is extracting the mineral.
No. Suppose I own this piece of land
Yes, my lord.
and there is a mineral reserve.
Yes, my lord.
Soil, subsoil, all rights belong to me.
Yes, my lord.
Correct? So, if this has to be extracted,
Yes, my lord.
who can extract it?
The owner can extract it, or he can engage anyone to extract it, my lord.
So, after this extraction,
Yes.
whether I sell it or not, whatever is there.
Yes, my lord.
So, the owner can give a license to someone to extract it.
Yes, my lord.
So, is it with the permission of the district council or the regional council?
No, it is all under the MMDR Act, because on the MMDR Act regulates the extraction of mineral, my lord.
No, but that is a central act.
That central act controls, even state has no independent power. And under paragraph 12A, my lord, all central act or state act will prevail over the customary laws or all laws.
So, this act came in 1950.
This act came in Lordship 1958.
Yes, 50.
57, sorry. 57, my lord.
Mines and minerals, also minor minerals.
My everything
Everything.
will cover. And there is another act which I noticed recently only, my lord, that is Indian Toll Act of 1851. Toll is, and there are two authorities on that point also. Toll is not in the nature of tax.
No, it's not in the nature of tax. There's no difficulty on
It's
that.
so compensatory. So therefore, if toll is being collected
It's basically you collect the toll for the purpose of maintaining the infrastructure.
that is being maintained by state government, my lord.
These are all on the national highway,
Next, our state highways.
state or
Yes. Viewed from that angle also, there are three propositions. One, the laws are in existence which control the transportation of minerals throughout country, including state of Meghalaya. Therefore, there is no customary right. That is one. Second, my lord, is that
to that. Sorry to interrupt, but to
Sorry.
that, the interpretation of the division bench was
Yes.
that, and you also admitted in your affidavit
yes, my lord.
that this was a system which was prevailing
Yes, my lord.
prior to the enactment of the Constitution.
Yes, my lord.
So this was saved under Article 32
Yes, my lord.
of the Constitution.
Yes, my lord.
If that is saved,
Yeah.
then they
Yes.
have a right.
So the question which falls for a lordship's consideration whether the customary rights have been saved in view of Indian Toll Act, Indian MMDR Act.
Or on the basis of the stand taken by the Meghalaya government.
My lord, your lordship is aware that the affidavit will not alter the affidavit. At best, will be interpretation of laws only.
No. What you are saying is absolutely correct, provided there is an enactment which supports the state, because there cannot be estoppel against the statute.
Yes, my lord.
So if there's a statute is there,
Yes, my lord.
and you may have said something wrong,
Yes,
which
my
is not in the statute,
Yes, my
that
lord.
will not create as an estoppel. That's
Yes,
fine.
Yes, my lord.
But you need to show them that when you file the affidavit,
Yes, my lord.
because this must be, your affidavit must have considered all this aspect.
Yes, my lord.
And what was your interpretation is one thing. You
Yes,
may
ma'am.
have wrongly interpreted. That's a different.
Yes, my lord.
So you need to show that that there is an enactment
Yes, my lord.
subsequent thereto, which has already annulled, repealed
Yes, my lord.
the customary benefits or
Yes,
the,
ma'am.
or the benefits that the tribes were enjoying prior
Yes,
to
ma'am.
that.
Yes, my lord. Now, so far as the subsequent enactment is concerned, I admit that there is no subsequent enactment, my lord. There is no subsequent enactment, my lord. There is the acts were already in existence when the judgment of the division bench of the Honorable High Court of Guwahati was delivered. The law was in place,
But these provisions of this mines and minerals were not shown.
yet not placed before the division bench. Indian Toll Act was not shown before. T. Kaji, if your lordship has seen, T. Kaji judgment was referred, powers of the district council,
Yes.
and these provisions were not shown, my lord. And on that basis, the division bench proceeds that customary tolls have been saved, as no post-constitutional law has been placed before the division bench of the Honorable High Court of Guwahati.
Now, who had given them the permission to construct? The district council?
No, my lord. Even district, because Sirdars are saying I have a customary right to collect, and therefore I have a right to
No,
set.
but for the purpose even making a construction, you don't require any permission. There's no law which, suppose today I can go out
Yeah, I
of this High Court
understand.
and make a construction.
We have to have law here. There
So
sometimes it's
for the
very.
Construction, whatever I made,
Yes, my lord. I have to take permission.
so whose permission is required?
Because in urban areas, it's a Meghalaya Urban Development Authority.
No, but for this
At
purpose,
this area, the power has been delegated by state government to Khasi Hill Autonomous District Council.
so this district council may have given them the permission to construct.
Yes, my lord. That they have not placed.
No, but what is the stand of the district council in the affidavit?
District Council is not party to it, but District Council in the earlier round of
No,
litigation.
but he has not been made a party here.
Yeah, KHDC is not a party because they are saying that I am not deriving my power from Khasi Hill Autonomous District. I have, your lordship has rightly observed, I have independent
But
power.
what did they say in the writ petition? That on what basis I am constructing? Because the construction has to have, it's not on his own land. It's on the national, near to the national highway.
National near to that. and the land is owned by Sirdar, my lord.
I think even in the National Highway Act also
Yes, my lord, there is a requirement.
there is a requirement, and
Yes.
there is also an area you cannot just build
Yes.
anywhere you like, the toll
Yes,
plaza.
and the difficulty which we are facing, my lord, as on today in state, that number of check gates are mushrooming in state, my lord, and that will lead to hampering of trade.
No. See, that's a different issue altogether.
Yes, my lord, I understand.
But that cannot deny a right to a person
I
if he has a right.
understand that limitation I have.
So
but
long there
at
is no
this,
statute in place.
yes, but at the same time, my lordship has to examine in terms of Article 19(1)(g) also. Right of a person to have the profession, trade and occupation, my lord. And if there is no law, and customary law is a law under Article 13, and the division bench of this honorable court has already held that in respect of KHDC, you have no power under 19(1)(g), your action is not backed by law.
Which judgment?
The Justice first judgment, my lord, that's Sajangyu judgment, and division bench also, there is a finding on 19(1)(g) also, that KHDC action is not backed by law.
But that is is it in conflict with the Guwahati Division Bench judgment?
The Guwahati Division Bench judgment also does not go into issue of Article 19(1)(g), my lord. It was not argued. But it was argued in the other judgment.
No. What you are saying is this: 19(1)(g) may be in place to regulate, as you said, that I cannot allow you mushrooming.
Yes.
But that is a restriction you may put. But you cannot say that you have no right. See, there is one thing. It is one thing to say that they have no right to construct.
Yes.
It is other thing to say that I regulate it. Say I do not may permit it to have one toll plaza between say 10 kilometers.
Yes.
So 10 kilometers I will not allow you to put a toll plaza. That could be in a fashion circumstances justified.
No, if I just illustrate, my lord, that in this case, your lordship have seen that 7 villages is having one ilaka. Every 7 villages or 5 villages, if those rights are protected under customary laws, my lord, they can set up the toll gate because they have customary right to collect it. The question is question of their customary right to collect toll on very face of art, because say that customary collection is a law which is protected by Article 13. My submission is, my lord, that the judgment on the basis of which reliance has been placed, 2 aspects have been clearly missed out, my lord. That laws even pre or post constitutional laws are in place, my lord. Like your lordship has said, National Highway Act. Those acts are regulating the setting of toll on national highway. Then we have Indian Toll Acts, 1851. We have got MMDR Act, where the transport challan is issued to the person before he carries the mineral from point X to point Y, my lord.
No, see, then you may admit, you may say that I admit that they have a customary right, but they cannot indiscriminately say construct toll plaza.
No, so, my lord, if they have customary right, my lord, then they have right to set up the check gate. Once they have right, my lord, I cannot interfere with their right. I am questioning their customary right, my lord. The very basis of foundation of their right. Because your lordship has seen that they are all creature of the law framed by district council.
You are trying to defeat their customary right on the ground of the Mines and Minerals Act.
That is one. Second, fundamental right. Because the customary right cannot take away my fundamental right.
No, then it comes reasonable restriction.
Yes, that 19(6) will come. Your lordship is right.
There's a reasonable restriction.
Yes, my lord. I understand.
Reasonable restriction can still be there.
Yes, my lord.
Even if you admit customary
yes,
right.
my lord. That's your lordship is right. Absolutely right. That then
even if you have a customary right, reasonable restriction.
Then arbitrariness, those tests will be applied, my lord. Whether they
so whether it is reasonable or not. So
yes.
Once it is established they have a customary right, then of course you have a right of reasonable restriction that remains.
Yes, my lord.
So whether your interference is really interfering with their is reasonable or not, that test has to be applied.
Yes, my lord. I bow down, my lord. That's a correct way to look into those rights. Now, third is, my lord, that the customary rights also, if your lordship, the customary rights, for that you have to produce material to show that these are customary. You can't simply rely on judgment and say that I have customary right. In that case, it was a CM, my lord.
No, but there you have a difficulty. There you have a difficulty because that part you have dealt with in your affidavit. It's a matter of fact, question of fact.
Yes, my lord.
The question of fact, you have conceded to that question of fact. It's not becomes a question of law
Yes,
to that extent.
Understand.
That some statutes are not being
yes,
shown.
I know. There is some difficulty in
That paragraph.
Yes, that paragraph is-
paragraph concedes to the concedes that they had a customary right.
yes, my lord. That paragraph says so.
It's 2016 judgment.
Remove it.
Very fine, excellent. He's part of it, but he has independent right. He's part of the district council, but he's established himself not in the capacity as a member of the district council. It's separate. Yes.
Yes, my lord. So what I place before your lordship is the MMDR Act. That first point, my lord. And the MMDR Act, your lordship will find in compilation 2. And in my written notes also, I have culled out the relevant provisions, my lord. If your lordship will kindly see page 8 of my page 9 at the of my note of submission on behalf of the appellant, my lord.
Yes.
And page 9, your lordship will.
Yes. Yes.
The grant of transport challan and payment of royalty is governed by the MMDR Act and rules framed thereunder for major and minor minerals, and therefore the district council has no jurisdiction should be to take executive or legislative action in this regard. Relevant provisions of MMDR Act, Mineral Concession Rules, Meghalaya Minor Mineral Concession Rules is quoted for ready reference, my lord. Section 23C of the Mines and Mineral Development and Regulation Act 1957 accords state government with the power to check illegal transportation of minerals, which includes the power of establishment of checkposts, inspection, regulation, and mineral being transported. Section 221(4) of MMDR Act provides for penalty of illegal transportation of minerals. Section 9 and 9A of MMDR Act provide for payment of royalty and dead rent prescribed by central government. Rule 27(5) and Rule 45, small Roman 4, Rule 53 and Rule 64 and 60 of Mineral Concession Rules, for instance, governs payment of royalty and dead rent to the state government. Rule 27-29 of the Meghalaya Mineral Concession Rules governs the payment of dead rent and royalty to the state government. Rule 26 of Meghalaya Mineral Concession Rules governs the grant of transportation challan, which is quoted ready reference. The competent authority shall issue transport challan in Form H to any lessee or permit holder who intends to dispatch minor mineral from lease area or permit area. No person shall transport or carry away any minor minerals from any place without a transport challan issued in accordance with sub Rule 1. Any person who transports any minor mineral shall shall allow the competent authority or any other officer authorized in this behalf to inspect the minor minerals in transit and to examine the transport challan in possession of such person. Paragraph 3. In Paragraph 12a(b) of the 6th Schedule, the President has the right to exempt the application of any Act of Parliament to any area belonging to autonomous district. Presently, no such exemption has been granted in regard to MDR Act 1957 and rules framed thereunder in respect of major and minor minerals. Therefore, it is submitted that said Act rules apply in full force in areas under KHDC. Consequently, grant of transportation challan to mineral-laden vehicles and payment royalty is governed by Central Act and rules framed thereunder. Hence, KHDC has no authority to frame laws or take any executive action to establish check posts to check transport mineral-laden vehicles. The action of KHDC, contrary to MDR Act rules framed thereunder, it is therefore null and void. In exercise of power under Section 15 of MMDR Act, the state government has framed Meghalaya Minor Mineral Concession Rules 2016. Rule 26 of triple MCR rules govern the grant of transport challan. Therefore, any action of district council check transportation challan is contrary to said rules and is void and nullity and power to issue challan in which competent authority appointed by the state government. Additionally, as per paragraph 12a, the district council's rules and regulations repugnant to laws made by state legislature is void. Accordingly, it is submitted the executive exercise of district council to the extent it is repugnant to the laws framed by state legislature is void. In the state of Meghalaya versus All Dimasa Union, 2019 8 SCC 177, the apex court held that autonomous district councils are denuded from making any law in respect of mining. Relevant paragraphs are quoted as under. Certain legislation framed by District Council has also been referred, namely Khasi Hills District Trading and Non-Trading Regulation 1954, United Khasi Jantia Hills Autonomous District Management Control of Forest Rules 1960, Khasi Hill Autonomous District Trading Non-Tribals Rule 1959, all framed in exercise of power under Para 3 of 6th Schedule. Power to make laws to law entrusted to Autonomous District Council under Para 3 of 6th Schedule is power to make law referable to List 2 and List 3 of 7th Schedule. We have already noticed above that with regard to regulation and development of minerals, Union has made declaration under Section 2 of 1956 Act and power of the state legislature is denuded in this respect. The logical corollary of the above principle is that power of autonomous jurisdiction shall also be denuded insofar as regulation and development of minerals to the extent covered under 1957 Act. Para 9(1) confines the licensee or lease of minerals granted by the government of state. Schedule 6, which constitute the district council and regional council, enumerate their powers. Para 9 refers to license or lease for extraction of minerals granted by government of the state. Para 9 only deals with share of royalties to district council as agreed between government of state and district council. And further, Para 12a itself contemplates that any law made by district council or regional council which is repugnant to any law of state shall be void. Thus, the status of law made by district council or regional council has to give way to the law made by state. There can be no doubt that district council, regional council cannot make any law which may be repugnant to the provisions of parliamentary. We thus of the view that district council does not have any power to make any rules, regulations, mining leases for winning the major minerals has to be granted under the rules, my lord. And 195 the union has made declaration under section 2 of that under the control and regulation development minerals. Power of autonomous district council to legislate on the subject shall be denuded that of legislature, my lord. Your lordship has seen Article 244, my lord. 2. It clearly says that the administration in tribal areas will be governed in terms of 6th Schedule, my lord. So, if the administration will of the tribal areas are to be governed under Article 244(2), my lord, and 6th Schedule has come into force, my lord, no customary right or customary practice of collecting toll will survive, my lord. 244, Article 244, sub-Article 2 leaves no scope of doubt, my lord, in my humble submission. And even if your lordship will see their power, because they are being appointed by Khasi Hill Autonomous District Council only. And recent judgment also of the 9 judges bench, my lord, in
Yes.
yes, my lord. So, if I take your lordship to these sections also, my lord, it is part of my compilation too, my lord. So, I have referred to the provisions, including recent Supreme Court judgment, my lord, of this 9 judges bench, my lord. Only one paragraph, paragraph 365, that is 2024 10 SSC page 1, my lord. And paragraph 365, my lord, at page 180.
Paragraph
365 at page 180, my lord. It was in the context of who has the power to collect royalty, my lord, which state or central government. Now, if lordship will kindly see 365 too. And 365 5, my lord.
No, this is in a situation where the sixth schedule doesn't come into.
No,
Sixth
because-
schedule doesn't come into in that situation.
No, my lord, the sixth schedule is subject to the provisions of parliamentary laws, my lord. Paragraph 12A clearly says.
See, but at the same time, 13.2 saves certain rights. You have to
13.
read the Constitution as a whole.
Yes, my lord.
If any right is preserved,
Yes, my lord.
that is preserved, settled under 13.2.
No, greatest respect, my lord, Article 13 preserves the right till the time there is no law framed by Parliament or the Constitution, my lord. Sixth schedule says under Article 244 to the administration of 6 scheduled areas will be as per 6 schedule only. Second, my lord, 6 schedule also says, paragraph 12A, laws made by state government and parliament will prevail over the laws made by district council. This is a law, customary law, my lord. It has to be subservient to the laws made by parliament and state government, my lord. In 6th schedule, that is what in T. Kaji, my lord, constitution bench, this was the debate, my lord. Whether the customary laws or the laws made by 6th schedule or laws prevailing before 6th schedule will bypass or will have no effect. That was, if your lordship will kindly revisit that T. Kaji's judgment.
No, that's there. The sentence is there, but that is in the context of power to appoint and remove.
Yes, my lord. That was in the context of power to appoint, the remove.
So you have to read a judgment in the context in which it is said.
Yes, my lord. That the
So the issue before him in this case
yes, my lord.
is not the issue before T. Kazi.
Yes, my lord.
So
To that,
facts are different.
facts are different. Fact situation in that case is different, but the principle which follows, my lord, is that no customary law will survive after.
That is in the context, as I said, but not in relation to the others. Because the difficulty is this, that 2-3 paragraphs in the judgment of the Guwahati High Court
Yes,
Division Bench
yes, my lord.
has even referred to that an inquiry commissioner was appointed.
Yes, my
An
lord.
inquiry was conducted
Yes, my lord.
to find out exactly whether this is a customary right or not.
Yes, my lord.
And based on that inquiry, the finding was arrived at.
Yes, my lord.
So that judgment which is there,
Yes, my
at
lord.
least establish
Yes, my lord.
that they were enjoying a customary right.
Yes, my lord. They were enjoying the customary right post-constitution also.
Post-constitution.
Post-constitution also. Now, my lord, if they have been enjoying the customary right post-constitution, deholds the law.
So suppose you take out mines and minerals.
Yes, my lord.
What about the other goods?
Now, the other is Indian Toll Act of 18.
No. If you take out mines and minerals,
Yes, my lord.
mines and minerals is one part of the goods.
Yes, my lord.
What about the other goods?
So far, other aspects is concerned, my lord, that I confess, my lord, that because here it was only confined to this toll.
This is not the end of the problem.
Yes, my lord.
You are citing mines and minerals to show that for the mines or any vehicle laden with mines and minerals
Lord.
has to be a toll plaza of the state.
Yes, my lord.
But if it is not laden with, say, mines and minerals,
Something else, my lord. Yes, my lord.
then that would remain. That issue would remain.
That issue would remain, my lord, and your lordship would adjudicate in appropriate case, my lord. That is what I would ask, my lord, because that issue would remain and that would be adjudicated in the facts
Because
of.
you wanted to make a distinction of the other judgments merely because of the fact that after the Constitution
Yes, my lord.
in 1958-59, this
Correct.
mines and minerals count.
Yes, ma'am.
So mines and minerals falls in the state list. Is a central list,
Yes,
list
ma'am.
one, and this entry, whatever is there, the state has to follow it
Yes, my lord.
because it's the union list.
Yes, my lord.
So no one. So according to you, by reason of this legislation,
Yes, my lord.
regarding any movement of mines and minerals after it's being extracted
Yes, my lord.
is to be governed by the
Strictly.
by the statute,
Yes, my lord.
and to that extent, if it is in conflict with any customary right,
Yes, my lord.
the rights of Mines and Minerals Act would prevail.
Yes, my lord. Precisely, I bow down.
But Mines and Minerals Act, Mr. Advocate General,
Yes, my lord.
is not so much with the ferrying of the things. It's with regard to the extraction right of the owner and
And a movement also, my lord.
so it's only in relation to how much you can extract, but it doesn't say that the subject to correction, that the vehicular movement of or the vehicle laden with mines and minerals.
That is also regulated by the MMDR Act. My lord, I will place the provision.
Which section?
Yes, my lord. If your lordship will kindly see that in my note also it is referred, my lord.
Yeah, actually.
It page 9.
You show the section, please.
Section. I'm sorry, my lord.
Now you
Kindly-
have referred to the transportation rules. I've
Yes,
seen
my lord.
that.
Yes, my lord. Kindly see the first section, page compilation 2. If your lordship will kindly come to compilation 2. I'll take to the substantive statutory provisions, my lord. And (23)(7), my lord, 23(7), 23C.
Yes, 23 is power of illegal.
Yes, power of state government to make rules for preventing illegal mining, transportation, and storage of minerals. My lord. Transportation also, your lordship will kindly see. The state government may, by notification in official gazette, make rules for preventing illegal mining, transportation, and storage of minerals, and for the purpose connected therewith, my lord. It's wide power, my lord. In particular, without prejudice to generality of the foregoing power, such rule may be provided for all or any of the following matters, namely establishment of check posts for checking the mineral under transit, establishment of way bridges to measure the quantity of minerals being transported, regulation of minerals being transported from area granted under prospecting license or a mining lease or quarry license or permit in whatever name the permission to excavate minerals has been given, inspection, checking and search of minerals in the place of excavation of storage or during transit, maintenance of register of forms for purpose of these rules, period within which and the authority to which applications for revision of any order passed by any authority be preferred under any rule made under this section of it. (23C), your lordship has seen, this is wide power to cover all aspects of the matter. And 21(4) is basically illegal. 21(4) penalties are also there, my lord. 21(4). Where any persons raises, transport or causes to be raised or transported without any lawful authority any mineral from any land, and for that purpose uses any tool, equipment, vehicle or any other thing, such mineral tool, vehicle, equipment, other things shall be liable to be seized by an officer and authority especially empowered in this behalf.
Just tell us which way those customer authorities manage their revenue. Whether district council allots any fund to them for say like we have CM of Millim.
Yes, my lord.
CMs are Siddharth are same.
Yes, my lord. Yes, my lord. Yes, my lord.
How do they manage? How do they manage their revenue?
Because the district council, they are the authorities under the district council. So, because they are exercising certain customary powers, customary practices, and they are also administrative authorities under the district council. Their own cases that they are elected by the rules.
Do you want to say the district council has some allocation of fund for them?
Because the powers to district councils are under paragraph 3 for administration of ilakas, etc. For that, the budgetary provisions have to be made by district council. If their district council is failing in the duty, that will not give the right.
Whether as of now, are they paying something?
That district council will be in position to answer the question. But the fact is that if they are discharging certain administrative or judicial or some functions, they should be funded by, or there should be budgetary provision in the district council to take care of their administrative duties. If we permit the customary heads to collect tolls in this way, my lord, the effect would be that the
So we can say that minus district council, all those customary authorities will lose their existence.
yes, my lord, because that's a legal position. Because customary, that's a legal position. Because Article 244(2) leaves no scope of doubt that administration in district council areas have to be run by in terms of 6th schedule only. And their rights, the rights which they are claiming under Article 13, that I have a customary right. And there is no customary right can be tinkered or interfered with when there is a parliamentary or state legislation, my lord. Customary right will not survive.
Collection to the It's very different connection to others. Where do you find this concept of siddhas and others in which act?
Yes, my lord. Those acts are there, my lord. Whether it compilation is there? No, it's not. These are 2 points.
Compilation of acts and rules. Compilation of acts and rules.
Compilation of the act. That in 2 volumes, my lord. And the first law which has been referred United Khasi Jantia Hill Autonomous District Administration of that act, your lordship will find that United Khasi Jantia Hill Autonomous District Administration of Election of Siddhar.
We are only thinking of that if we accept your submission, then what would be the position of this siddhar or the chieftains who are maybe there?
They will continue to exercise the powers which have been delegated to them by district council or governed by rules of the district council. And so far as source of revenue or earning is concerned, the lordship has seen under paragraph 3, land revenue is required to be collected by them in Ilaka. If it is insufficient to maintain the law and order or discharge of their function, my lord, then budgetary provisions can be made. But this way, what is happening, my lord, is that the sirdars are appointing agent.
Now, where is the provision for budgetary allocation?
This is all under the District Council Act, paragraph 3
Now,
itself.
budgetary allocation has to be by the state government.
No, my lord, the budget, if your lordship will see 6th schedule, paragraph 3, they have got the legislative power, they have got executive power, and in case of and in paragraph 9, the sharing of royalty takes place between the state government and the district council. Paragraph 9 of 6th schedule.
But what is the source of
Their source is they
land
collect
revenue,
land revenue, professional tax, trade tax,
license?
license.
Land revenue probably is 6 schedule also. You see?
Paragraph 8 of the 6th schedule, my lord. Power to assess and collect land revenues and impose taxes.
But the land revenue is rich. Receive that.
There are, my lord, 5 heads under which they can collect.
Yes.
Yes, my lord. Your lordship will see paragraph 8 of the 6th schedule where the powers are conferred on the district council to.
That we have seen.
Yes, my lord. So, and in paragraph 9, sharing of mineral royalty is also there between district council. So, these are the sources of revenue of the district council, my lord. And they have to use that revenue for administration of their respective ilakas, my lord. So, if your lordship was putting the question that their powers, if their powers are also regulated by the laws framed by district council, my lord.
All Siddhas and everyone.
All Siddhas, my lord. Their appointment is under the district council rules only. If this, and your lordships have held that district council has no power to collect or toll, the question of Sirdars, which are officers of the district council, will have no power, my lord. So my case is, my lord, based on this, and then kindly see the findings, the reasoning of the learned single judge on this aspect, my lord, impugned judgment, my lord. And before I take your lordship, there is a act also, my lord, Indian Toll Act.
How long you will take, Mr. Counsel?
I will, my lord, I have shown the relevant provisions of the MMDR Act and all. And another 15-20 minutes I can conclude.
And you, Mr. Counsel?
Well, I will take an hour subject to lordship permission to collect.
Then can we fix it tomorrow?
Yes, my lord. We'll have it tomorrow.
So can we fix it sometimes tomorrow at Then we keep it on Wednesday.
Yes, my lord.
Huh.
Yes, my lord.
Because today I will sit with his
Yes, my lord.
So
Yes.
we keep it on Wednesday at 2 p.m.
Yes, my lord.
At 2
Yes,
p.m.
my lord. Yes, my lord.
Hard in practice. Please send it to my chamber. Those books. This will also go. Yes, what is item number 2?
This is a criminal appeal, Lordship. It's fixed for admission today.
Is there a delay?
This has been conviction under 302, Lordship. Sentence life
302.
imprisonment.
No. Is there a delay in filing?
Delay has been condoned, Lordship.
No. Then usual order. Usual order for the LC appeal admitted. How long you are in incarceration?
Your Lordship, 4 weeks for preparation of paper book.
No.
Punishment.
How long? Incarceration.
Life imprisonment, Lordship. He's been inside since 2024.
Usual order. So waive service of notice. What will you get?
My lord, we have taken steps with regard to newly implicated parties. Service report is awaiting. If Lordship give us a week's time, we will obtain the report from postal office and file a service evidence.
তো এই বেঞ্চে শুনেছিল না আচ্ছা Have you served upon the newly implemented
Well,
respondents?
we have taken steps to register post. 14 to 17.
Notice has been issued.
Yes.
So, what is the office report? Latest office report. 9th October, ID card has not been received. Why not? What is the latest report? Ask the office to file a report, huh? We keep it after 1 week.
My lord, in the meantime, we were also allowed to obtain the report from the Poster General and place the report through service evidence.
Sorry?
My lord, if Lordship allow me to obtain the Postal Service report from the Poster General and allow me to
Yes,
file
you
a
have-
service evidence.
Yes, no problem. The report as regards.
Number 5.
Also said this to me. Yeah? Yes. 5.
May it please,
My witness 1154
My lord.
days. Okay, yes,
My lord, this is an application for condonation of delay of 1,154 days in preferring writ appeal.
yeah, please.
My lord, the explanation for the delay,
1154.
my lord, what has happened here is there has been a medical emergency in the family, and thereafter, and corresponding financial hardship, my lord. That is the
Who
reason.
is opposing?
My lord, they have filed the.
We filed
objection.
our objection, Your Lordship.
My lord,
You are seriously opposing.
Lordship, there is a delay of 1154 days, Your Lordship. And plus, Your Lordship, the
It's
explanation.
almost 4 years. Nearly 4 years.
close to 4 years, my lord.
Lordship. And the explanation also, in my humble and respectful submission, is not satisfactory, Your Lordship. If Lordship kindly have page 3, paragraph 4. 4-5.
Disciplinary proceeding.
Lordship,
My lord.
yes.
My lord, this is a
Unauthorized
disciplinary.
absence.
It is a. My lord, it was an ex parte proceeding, my lord. Ex parte proceeding, my lord. If you ex parte proceeding.
Any final order has been passed.
Yes, my lord. Final order has been passed, my lord. I have been removed from service, against which I filed a writ petition before the Honorable High Court. The Honorable High Court dismissed my writ petition, my lord. My lord, this is a case of an ex parte proceeding, my lord, and it was a premeditated proceeding in the sense that even before the show cause notice was issued to me, my lord, the inquiry officer was appointed. So clearly, my lord, the authorities had already made up their mind to remove me from service, which is understandable by the fact that the inquiry officer was appointed prior to the issuance of the show cause notice itself, my lord. But of course, that is on the merits. Now, now the learned senior counsel appearing for the state, he has filed his show cause, in which he has stated in paragraph 4 that the explanation which I have provided is not sufficient, my lord. He states that that I seek to explain the delay of over 3 years, citing illness and subsequent demise of my uncle and financial hardship, my lord. That is what prevented me from approaching, pursuing my remedy before the appellate court.
No, for every sitting,
My lord.
notices were issued to you. For every sitting, you see, the learned single judge
My lord.
has considered that on each date when the PWs were examined,
My lord.
notices were issued to you.
My lord.
So, in spite of notice, if you don't appear, then on what basis we should allow this?
My lord will kindly consider the fact that the inquiry officer was appointed on 22/1/2016.
That is not the point. We are only on the point you allege
My lord.
that there is a violation of the principles of natural justice.
My lord.
Now, the inquiry officer was appointed.
My lord.
He has given you notices. It's not the fact that you have not received the notices.
My lord.
If, in spite of receipt of the notices, you don't participate, can there be any violation of the principles of
My
natural
lord,
justice?
my lord, what actually happened was that when the notice was published in the newspaper, when I
Not
came to
published.
learn,
Come to Romans 7 of the judgment.
my lord,
On 7 June 2016 onwards, statement of PWs.
my lord.
8 in number were recorded and it is noted before each sitting. Notices duly issued to the petitioner. Received. Then? Since you are not appearing, they have issued newspaper publication.
Yes, my lord, they issued newspaper publication. My lord, what actually happened was that while I was posted in that station, my lord, I fell sick. Then thereafter I was referred to a bigger hospital in the city, my lord. There I was.
You should have written a letter to them. Once you receive these notices, the first thing you should have done, that I am indisposed, I am unable to attend, please postpone it.
My lord, my lord, in my petition, I have categorically made a statement that I had gone there. My lord, when I went there, the commandant was not there. I was asked to come after a few days. My lord, within that time, the impugned order was already passed.
No, but if the impugned order has passed,
My lord,
the services must provide
My
for
lord.
an appeal also.
my lord,
There must be a provision, Mr. Counsel.
there is a provision, my lord. Under the rules, there is a provision for appeal, my lord.
In the appeal, why don't you take up this point and let them reconsider it? If it doesn't, then we shall see to it. Have you prepared a statutory appeal? Instead, you file a writ.
My lord, I have prepared a my lord, only after the statutory appeal was rejected, my
Mr.
lord.
Counsel,
Lordship.
subject to what you say on this, what we feel, there's a final order has been passed.
Lordship.
Writ petition was pending, and for that possibly he has not preferred the statutory appeal.
Lordship.
My lord, I have preferred the statutory
Appeal
appeal.
has
Preferred statutory
Yes,
appeal.
my lord. My statutory appeal was rejected, my lord.
Was rejected.
Yes, my lord.
Your Lordship is.
It is only after the rejection of the statutory appeal, my lord, I filed a writ petition under Article 226 before the Honorable High Court, my lord.
So statutory appeal was there. You have also disclosed the reason for not being able to attend the inquiry proceeding. Have you said so, or you challenge this order on merits?
My lord, the grounds of the appeal, my lord, the statutory appeal is at page 83 of the of the memo of appeal.
Have you challenged the order of dismissal or proposal for dismissal? You made a representation. You must have made a representation with the disciplinary authority. And against the decision of the disciplinary authority, you must have preferred the statutory appeal.
Yes, my lord.
In the appeal, you must have taken the point that the reason for
My lord,
not
one of the ground taken in the appeal was that I was removed from service without hearing, without affording an opportunity of being heard. That was one of the grounds taken, my lord. My lord, my short point for argument before my lords is that my lord, firstly, it was a ex parte proceeding, my lord. Now, secondly,
you can't. If in spite of notice you don't appear, you cannot say it's an ex parte proceeding.
my lord, the second limb of my argument would be that, my lord, it was premeditated in the sense that the inquiry officer was appointed prior to the show cause notice being issued, my lord. My lord will kindly appreciate that the proceeding commences with the issuance of a show cause notice. My lord, thereafter, the delinquent is given an opportunity to file a show cause. Now, it is only when the authority receives the show cause the show cause notice, he goes through the show cause provided, and if it is not satisfied that sufficient grounds have been given, then only thereafter he passes an order that the disciplinary proceeding will commence, and subsequent thereto an inquiry officer is appointed. Here, my lord, what has happened is the show cause notice was subsequently issued, but prior to that, my lord, the inquiry officer was appointed. So therefore, my lord, my contention is that
No, but even if
it was a premeditated exercise, my lord.
premeditated exercise,
My lord.
but nothing had prevented you from appearing and saying that this was to prove your innocence. To prove your innocence.
My lord, this is a case of absence without leave, my lord.
He was dismissed on the ground of unauthorized absence.
Yes, my lord. It was
For how many days?
Lordship, if Lordship kindly come to page 19, that is the finding of the learned single judge.
We have seen that.
Lordship, yes.
No,
807 days.
How many days?
807 days, Your Lordship.
307 days.
Lordship.
807.
807 days.
Yes.
And my lord, I have, my lord, the fact that salary was always given to me for during that period as
Lordship,
well. My
kindly
lord.
come to page 17, internal paragraph 6 of the judgment. That is the summation of the state before the learned single judge.
You have given answer to the show cause.
My lord.
You have given answer to the show cause.
No, my lord.
Sorry. No.
My lord, before
Sorry, nothing you have done. Sorry, we can't. There is a delay of 1154 days in preferring the appeal.
I never had the occasion, my lord.
The conduct of the appellant.